meetings and town halls, and you look at today's meeting, you'll also be able to get the attachments there. We are recording. Thank you for consenting to that. Chair Mundo, I think we can get started anytime you want.
Sounds good. Thank you, Wendy. Good afternoon. Today is Wednesday, January 22nd, 2025, and I want to thank you for joining our virtual town hall meeting this afternoon. My name is Eduardo Mundo, and I am the chair of the Probation Oversight Commission. The purpose for today's meeting is to explore and to provide a snapshot of one of the most significant reports that probation provides in the juvenile system. And it's actually one of the most significant processes in the juvenile system. So hopefully by the end of today's town hall, you'll have a better understanding and join us in making sure that the county is responsible in the way it employs the process of transferring a youth from juvenile to adult jurisdiction. I will introduce the panelists, then POC Executive Director Wendy Julian will share some ground rules for participation, and then we will proceed with the presentation, a discussion with our panelists, and conclude with comments and questions from the public. Again, thank you, panelists, for joining us today and for all your work with youth in the justice system. We appreciate your willingness to talk about this issue. Joining us today, we have Catherine Lucero, Director, Office of Youth and Community Restoration. Laurent Dennis, Office of Youth and Community Restoration. Melissa Sandoval, Youth Division, Los Angeles County Public Defender Office. She is the Deputy in Charge at Compton. We have Frank Santoro, Assistant Head Deputy to Juvenile for the District Attorney's Office. And myself, Chair of the Probation Oversight Commission and a retired probation officer, supervisor from LA County, over 35 years of experience in the field. Wendy will please explain how people can participate in today's virtual town hall.
Yes, thank you, and welcome everyone who's joined us, those of you who are here on WebEx and watching on YouTube. I'm also really extremely thankful to all the panelists today. Everybody here is a volunteer, except me and Janae and Ismail, I guess. But we really appreciate you volunteering to be here for today's panel. Our virtual town hall is being recorded. It's being broadcast live here on WebEx and also on our YouTube page, but there's no engagement with the viewers on YouTube. If you want to participate by making a comment or asking a question today, you have to log on to the WebEx. That link can be found on our webpage, poc.lacounty.gov under meetings. Today's town hall is not governed by the Brown Act. We don't have a quorum of probation oversight commissioners here in their official roles, and no actions will be taken today. We really want you to participate. We will do our best to leave plenty of time for comments. If you don't want to comment live today, you actually have two choices. One, as always, you can email us at info@poc.lacounty.gov. But also just for today, if you have a question and you want me to ask it, if you want to send it in the chat, I will ask your question for you. We don't usually do that, but we're going to try to do that this time. After we hear the presentations from Chair Mundo and the panelists, we'll go to public comment. We don't like to have time limits on the public comments in our town halls, but it depends on how many people raise their hands. Unlike public comment in our regular meetings, you have the opportunity to speak a little more freely in terms of asking questions of the panelists, and we will leave it up to the panelists whether they want to answer your question or not. I assume that most of them will. The way you participate is to use the raise your hand function. You tap the little icon at the bottom of the screen that says raise your hand, and we'll add you to the queue. If you're calling in, you have to dial *3 on your phone to get in line, and then we'll call you by your phone number. You will have to unmute yourself when we call on you by pushing the unmute button if you're on WebEx, or *6 if you're on the phone. Buenas tardes, bienvenidos. Ya se ha iniciado la conferencia por WebEx y también por YouTube. Estamos grabando. Si quiere participar, tiene que estar en la junta vía WebEx. Y en nuestro sitio de web puede encontrar la manera de registrarse a través de WebEx. Si quiere hacer una pregunta o un comentario público, por favor haga clic en la imagen de la mano y le llamaremos cuando sea su turno. Si está escuchando la conferencia por teléfono en Webex y quiere hacer una pregunta, presione estrella 3 y alguien le ayudará. Si necesita traducción o tiene una pregunta, por favor indique eso al comienzo de su pregunta. Yo le puedo traducir o también usted puede proveer su propio traductor. We'd ask that you abide by the following guidelines during today's meeting. Again, everyone who's here is here voluntarily, and we really appreciate that. Please introduce yourself, share your thoughts, and be respectful of the time so as many people can speak as possible. Remain respectful and honor equity and participation. We ask that you practice grace and openness with each other and use I statements to speak your own truth. With that, I am going to hand it back to you, Chair Mundo.
Thank you, Wendy. And I neglected to include Beth Stiffelman, attorney, defense attorney of the Law Office of Beth Stiffelman. She is our lead today. She will be talking about the process and how it came about and what the current legal parameters are, and then give us an idea of the steps that go along. So go ahead, Beth.
Bess, I can't hear you. I think
She-
I can't tell.
Yeah.
Here I am. I need to
There we
unmute
go.
myself. Thank you. All right, thank you so much. So I'm just going to dive in because I know we don't have a ton of time, and I just wanted to kind of outline the basic current transfer law, so that we're on the same page, and then hopefully also touch on some issues that have been coming up in my practice. Although I'll move through that a little more quickly, that I think is going to be a big part of transfer in LA County over the next year. All right, so section 707, subdivision A3, sets forth the transfer factors. This is the law that governs how we transfer a minor to adult court. And so there are 5 factors that are looked at. It's the degree of criminal sophistication, whether the minor can be rehabilitated prior to the expiration of the juvenile court's jurisdiction. And I'm going to talk about that factor again in a second. But just remember that one is sort of nuanced under current law. And then the minor's previous delinquent history, like whether they had prior arrests and what they were for, success of previous attempts by the juvenile court to rehabilitate the minor, and the circumstances and gravity of the offense alleged in the petition. It used to be that the circumstances and the gravity of the offense alone were enough to transfer someone. The law has changed. If we go to the next slide. Can we go to the next slide, or do I have control over that?
I think it changed. Did
Oh,
it
there we
change?
go. Thank you. So AB 236 changed the law. Wait, is it 23? Yeah, 61. I'm sorry. Changed the law, but it went into effect 2023. It changed the law of transfer. It raised the prosecution's burden of proof to clear and convincing evidence, and it required a new finding regarding amenability to rehabilitation. And it also requires the court to state the reason supporting a finding that the minor is not amenable to rehabilitation. So what the real rest of this law, and if we could go to the next slide, is about this additional criteria. So there's a new rule of court that explains what needs to happen. And it says you look at all of those 5 factors like we have in the past, but then there's this ultimate finding that the court has to make, that the youth is not amenable to rehabilitation while under the jurisdiction of the juvenile court. And it's that last piece that becomes an issue in a lot of cases, is how much time is left to rehabilitate the minor, which is how far out is the jurisdiction. If you go to the next slide. So this is just a case that's trying to explain sort of how this new law actually works. The ultimate finding concerns a global assessment of the minor's suitability to rehabilitation within juvenile court system. And so it's not just a comparison of the time needed, but it's sort of this global assessment. At least that's how the case law has been interpreting the changes in the law, the higher burden in that ultimate finding. So the next thing, and this is going to be, critical to probation, is that what is presented, one of the primary items that is used in a transfer hearing is the probation officer's report on behavioral patterns and social history of the minor. So that's actually, specifically outlined in the statute. And then in addition to that, it's any other relevant evidence. So it's very, very broad. And a youth has a statutory and constitutional right demand proof of a prima facie case and that has to be with credible non-hearsay evidence. But other than that, a lot comes in, reports, social histories, documentation of what happened in juvenile hall, any kind of rehabilitative programming comes in. All right, next slide. And this comes up in appellate decisions that there was insufficient evidence to transfer the minor because the report that rehabilitation provided was not based on, the opinion rendered was not based on sufficient facts. So I just wanted to share that. Next one. Okay, so one of these first steps is obviously if we're going to figure out whether or not a minor can be rehabilitated within juvenile court jurisdiction, we have to determine what their rehabilitative needs are. And there are just some sites on that. Next one. Okay, so this is the sort of additional thing I wanted to talk about that I think is going to be affecting us a lot over the next year. I don't know what the numbers are exactly, but my day-to-day experience, it seems like there are as many hearings for retroactive transfer hearings, so hearings for former minors who are returning to juvenile court, as we have pending hearings for current minors. And what I mean by that is people whose sentences have been recalled and they've been sent back to juvenile court to conduct a hearing. And some of these former minors are going to be in their 50s and 60s. I know we had one recently of someone that was in her 60s that did remain in juvenile court. Next slide. You know, the courts have said, this is a California Supreme Court decision that said we're sending these back. These are complex. It's hard to figure out whether or not you would transfer someone when they come in before you as like a 40-year-old. But the courts have said that it's complicated, but we still are going to do it, and we're going to try to figure it out. And some of these people should remain in juvenile court. Next slide. And then the question is whether or not the court would have transferred the minor. However, next slide. Oh, sorry, I'm going to stay with this for a second. When we're talking about, go to the next slide. I forgot I put this in here. There was a change in law last year, which extends jurisdiction in juvenile court for 2 years for someone who is returning to juvenile court, who's a former minor. So for example, someone's 40 years old, the court tries to determine whether or not they should be transferred. When they're looking at that question, can this person be rehabilitated within juvenile court jurisdiction? It's going to be 2 years from the date of the disposition that there is juvenile court jurisdiction over that former minor. So we have a lot of people right now that are in this place, and a lot of them are in SYTF step-down facilities, but they have juvenile probation officers, and you know, they are in their 30s and 40s at times. Next slide. This is what I was going to talk about before, is when you're dealing with these former minors and anybody that has a transfer hearing, the courts say you don't just look at what happened at the time of the crime, you look at any kind of rehabilitation subsequent to that offense. So for example, if you have someone who's 40 years old, who's been in prison since they were 16, or been in custody since they were 16, you actually have to look at the rehabilitative efforts made up until that transfer hearing, and then whether or not 2 years of juvenile court jurisdiction is going to be sufficient to complete that rehabilitation. I think the analysis, when we're talking about a returning former minor, the question really is, are there enough services for them to safely return to the community? And because, you know, they've done a lot of programming, right? A lot of them are coming back rehabilitated. The question is, what services do they need for a period of 2 years? Next slide. And then important fact is the hearing is conducted under current law. You know, all current laws apply. So if someone was, for example, this is a case where someone was returned for a transfer hearing in theory, but they were 15, and 15-year-olds can't be transferred anymore. So they actually conducted a transfer hearing, and the appellate court said, no, you can't transfer a 15-year-old. If you're going to do a transfer hearing, all current laws apply. You're applying current transfer law. Next slide. And then along with those other amendments, there was an amendment saying that these former minors should not be housed with juveniles, unless there's some express reason why they should. But presumptively, they are not housed with juveniles. Next slide. And now here, these guys are doing great. And I just have a couple of photos. The next few slides, you can just scroll through. Some of these are some of the returned former minors that I've worked with. They have probation. I think the people that work with some of these guys really will attest that they're some of the easiest clients, because the ones that are staying really are already rehabilitated, but they do have, I mean, they are coming under juvenile court jurisdiction, and we've been working with community partners, but these guys really do need that 2 years of supervision to help them reintegrate safely. All right, thank you.
Thank you, Bess. So when the process starts, it starts with the district attorney's office, and Frank Santoro is here to speak on the process there and how the office determines whether or not to move forward with a motion for transfer of jurisdiction. Frank, thank you.
Thank you. Hi, everybody. My name is Frank Santoro. I'm a deputy district attorney. I'm the assistant head deputy of the juvenile division, which is across the entire county. And we have 8 juvenile offices throughout the county, 7 of which are courts. One is not a court, it's just a separate office dealing with juvenile issues. I've been a DA for 27 years, and I've been in juvenile for about 8 years. So as you know, obviously, we've had a recent change in the district attorney's office, which means changes in policies. The current district attorney, Nathan Hockman, in December put out his policy on transfer. He created what is called a Juvenile Justice Committee. The committee is composed of myself, the assistant head deputy of the juvenile division, the head deputy of the juvenile division, and the bureau director over what are called special ops, which includes juvenile and several divisions that specialize, like sex crimes, the gang division, and so on. So the way it works is cases come in, they're filed by police officers like any other case, except they're brought to the juvenile division. And juvenile has jurisdiction over anyone who committed a crime while they were a juvenile, even if they're now 30 years old. Each of the 7 juvenile courts has a deputy in charge, and those individuals at the courts, along with the DA who's assigned the case, is going to determine, should we try to transfer this kid or not? Do we want to try to transfer this kid or not? If they decide they do, they write a memo, which goes up the chain of command to this new committee that I'm on. And we look at what you might expect, the obvious things, the transfer law, which was just gone over, the 5 factors of the transfer law, any additional information that's given to us by the defense, or any additional information we become aware of. We evaluate it, we look at it, we talk about it, and then we make a decision. And then that decision is sent back down the chain of command to the deputy in charge and the DA, and the defense attorney is notified, and so on, and the court is notified. That's the basic process of how it's worked. The prior district attorney instituted a similar process with a committee and a memo requirement. And so the current district attorney's office is actually not that different than what the prior DA had put in. Just to give you some idea about statistics, like I said, I've been in juvenile for about 8-9 years, so I've seen what was happening with transfers prior to the changes in the recent law and the change in district attorney. 57, which first came out in 2016, I believe November. I was already in the district attorney's office juvenile division at that time. And the transfer law, section 707B, has been amended several times, with the most recent one being 22 and 23. When Proposition 57 first came out, it didn't change the standard too much. So there were still efforts to transfer people, and they were still, I guess for lack of a better term, the law wasn't as strict as it is today. So prior to the district attorney Gascon taking office in 2020, our statistics from 2016 to about 2020 were about 60% of the time we asked for a transfer, we were successful. And keep in mind, Prop 21 back, God, that was like 2001, gave the district attorney's office direct filing. So if the district attorney's office wanted to file a case, an adult case against a juvenile, they could do that. There were some nuances and reasons and different technical issues of what charges you can file and so on. But generally, the district attorney's office could make the decision. Prop 57 eliminated direct filing. So now anyone who is going to be prosecuted as an adult has to start out in juvenile court and be transferred to adult court. So again, that change occurred in 2016 with Prop 57. From 2016 to 2020, we were about 60% successful, or the motions were granted. And it varied on the court, right? Some courts are granted more of these than other courts, but that was the county average. When the DA Gascon came into office in 2020, he stopped all transfers to adult court. In 2022, he started that up again, and he started a committee, kind of similar to the one we have now, and he started entertaining transferring people back to adult court. And my office kind of split those cases into two categories. Just, these are terms we don't really use anymore, but just to explain it and make it clear. There were the first category, which was called JACE, was 16 and 17-year-old. These are the kids who are now 16 and 17-year-old committing crimes, and we were attempting to transfer that person to adult. The second category, which was already touched on, which we called non-JACE, were the adults coming back to juvenile court. And they came back in three ways, right? There's Prop 57 returns, as we call them, which the Defense Attorney Council already talked about. And those are people in custody, and for various different legal reasons, their cases are no longer final on appeal, and they have a right to come back to juvenile court. So they come back to juvenile court, and we have to decide what to do with them. Also, cases filed for warrant. Someone may have committed a murder when they're 17 and not gotten caught until they're 25. And then there's cases that were filed as a juvenile, but the person may have fled and not been arrested. So those three types of cases are all adults coming back to juvenile court. So they were treated a little differently, and they were evaluated for being transferred back to adult court. And just to give you an idea, since 2022, again, these are not, I'm ballparking these stats, and just to give a general idea, there are about 100 cases of 16 and 17-year-olds committing crimes where my office was going to attempt to transfer that person, where it was first initially started by the DIC or a DA, and we said we might want to transfer this person. And almost no transfers were attempted other than murder cases and serious sex crimes cases. Even though the law says you can attempt to transfer someone for pretty much any felony offense, our office would not even bother trying to transfer someone unless it was a murder or a serious sex crime. The one exception to that is if there were juveniles who maybe they were committing robberies, maybe they were doing shootings, maybe they were hurting people, but it didn't rise to the level of a murder. And no matter what we did, no matter what sort of disposition in juvenile court or sentences you refer to in adult court, that individual didn't change their behavior. They just kept coming back and back and back, and nothing stopped them from committing crime. I've seen one or two of those people transferred to adult, even though they did not commit a murder. The vast majority is murder. So of those 100 cases, the process would start out with the DA in court, their DIC would go up the chain, eventually we'd ask for permission. Those 100 cases, we were not seeking transfer in all of them. A lot of them would plead along the way. We would find out they have some sort of mitigating circumstances. Maybe there's mental disability or justifications or self-defense or whatever the reason. So it's almost like a pyramid trickling up to the cases that we actually seek transfer. And when the transfer law was first changed in 2016, the San Diego District Attorney's Office coined the term that this is the new death penalty case. And if you think about it, what they're really saying is this kid's life is on the line. He's going to stay in juvenile. And even though the maximum sentence is up to the age of 25, that is not the age people are spending in custody. They're spending 2 to 3 years on a murder. So you're either getting out in juvenile or going to adult and facing 25, 50 to life. So it's a big deal. So they don't go to adjudication quickly. So all of those cases, those 100 cases, only 6 of them have actually gone to transfer hearing. And 5 of them were denied and 1 was granted. And those are in the juvenile division. There are other divisions that have tried to transfer people, and they keep their own statistics and so on. And that just, all of those have been since the law has become a lot more difficult to transfer someone, a lot more critical. The non-JACE Jace cases, the adults that are coming back, and the adults that are being arrested on warrants or being solved as cold cases. We've had about 100 of those since 2022. And only 8 of those have gone to actual hearing, and half of those have been transferred to adult and half have not. So you see the significant difference in the courts granting these of sending someone who's an adult back to adult court. Probation has come out and said openly they don't have any services for adults. Their entire system is based on the idea of the lack of development of the juvenile mind and the juvenile brain. So when someone comes back into 35 and 40, probation doesn't have any services. So at that point, it becomes an issue of, is this person already rehabilitated or do they need more time to rehabilitate? And a lot of the people we see coming back have done very well, which is why their case is back in juvenile, without getting into too many technical reasons of why. But a lot of them are rehabilitated and then can be fined with a step down in juvenile. And although the law was changed, the 2 years that was talked about, you've been allowed to send an adult to what used to be DJJ, which was the juvenile prison before what's now called SYTF for many, many years. You can send for 2 years. And then when the SYTF law was created, which is now the county version of juvenile prison, you're also now allowed to send that person for 2 years. And you can have 2 years jurisdiction, which is again what council was talking about. So they don't have to go to SYTF. So the statistics in our society have been very clear. When someone's in prison for 10, 15, 20, 30 years, and they get out and we just throw them on the street, they don't do well. It's common sense. You would expect them not to do well. So a lot of the juveniles or the former juveniles that come to juvenile, we do what's called a step down. So they get out of custody and they go to some sort of halfway house. They go to a live-in facility. They go to a place where they can get their life going again, where people are going to help them. So they're not just being thrown back out on the street. And our parole stats and our recidivism stats show that, not just with these cases, with all cases, that they'll do much better if they get help. So that's what happens in the vast majority of those cases. I'm not sure of any of those 4 of the 8 transfer hearings where someone stayed in juvenile, they were put in an SYTF facility. They were almost all, I believe, I'd have to check, sent to some sort of halfway house where they were let out and given services to try to get their life back on track. So that's just a little bit of historical data. I don't believe probation has any data on their SYTF kids yet, or people that have gone, or adults that have come back there. Just to give you an idea of what it is. So that's basically how the decision is made, what's been going on with the transfer law since 2016 and it changed, and how my office is handling it right now. And I'm happy to answer any other questions, and that's what I wanted to explain today. So thanks for having me, and thank you.
You need to unmute Commissioner Mundo.
Sorry, Mr. Santoro, before I move on to the public defender's role and how they view the process in LA County, in the number of cases that actually went to the level that a report was submitted by probation, what percentage of those cases were probation recommending or finding the youth not amenable to juvenile anymore and arguing or recommending that they go to adult?
You know, I get asked a lot about statistics. PRAs are submitted, for example, for statistics, Freedom of Information Act requests, which is the federal version. And we only keep certain statistics. Our computers only track certain things. So that's an example of something our computers don't track. I mean, if I wanted to try to find that out, I would literally have to ask my DAs in the 7 offices to go back and start digging through files one by one to find that out. So unfortunately, that's not a statistic we have, so that I could give with any accuracy. I would suspect that the majority of the people that we are seeking transfer on, probation was agreeing with that, but I know there have been some times where they've disagreed, but I couldn't give you any accurate number.
Okay, thank you. Thank you.
Looks like Bess had something to say about that.
I was just going to note, anecdotally, my experience is that they're not going to go forward with a transfer hearing without probation recommending transfer. So in almost all of those cases that they talked about that had hearings, probation would have been recommending. I know one case where probation did find the person amenable to rehabilitation, and then after consultation with the DA's office changed their position in the hearing. That person did remain in juvenile court despite the shift in the statement.
And one thing I've noticed is generally when you had an adult returning to juvenile, in the beginning, the probation reports we saw all basically said they should go back to adult because probation doesn't have services. Probation's job is not arguably to provide services to 40-year-olds. They're, by statute, they're designed to work with juveniles. Then it seemed like there was a switch. Then it seemed like now all the adults that are coming back that are doing well now have recommendations that they should stay in juvenile. I don't get involved in that. I'm sure there's some politics as to why they switch, but I can just say the district attorney's office tries to evaluate or does evaluate our individual decision for each case based on what we think, despite any other outside influence.
Thank you.
You're welcome.
So Melissa Sandoval is here with the Office of the Public Defender, and she will explain how a motion to transfer impacts the public defender's decision and the work on the youth's case. Thank you, Melissa.
Hi, good afternoon, everyone. So from my office's perspective, when we get the transfer motion, it's usually filed when we get the petition. So right from the start, the transfer motion is filed. My experience, and this is anecdotally based primarily on the cases that we get here in Compton, most of, if not all of the transfer motions, I think except for one, have been on murder cases. I've been the deputy in charge here since I think 2020, 2021. And I think we've seen the cases that my office has kept, because we declare conflicts and they either go to the alternate public defender or to the IDCO, what used to be called bar panel. But I think we've seen about 7. Back when Gascon was the DA, I think most of our transfer motions were withdrawn after we presented mitigation in the form of expert reports, or if we wrote memos detailing the child's adverse childhood experiences in a formal memo. Not all of them were withdrawn, but I would say maybe about half were. Under DA Hockman, we haven't yet submitted a mitigation memo. I will say I haven't seen an increase in transfer motions. I think since, like I said, most of them were done on murder cases. The office-wide, I think the public defender's office has about 22 transfer motions filed. I'm unaware of any of them being filed against girls. I think it's all boys, and I didn't really get a chance to see what the charges were. I think we have fewer of the Prop 57 returns than probably APD and bar panel, because back when we usually represented the adult on those types of cases. So we usually have to conflict off of those. But we do see them here and there when they're 15-year-olds and the transfer can't be filed. Our goal is to get them the services so they can transition and rejoin society. And that's usually done with the help of the Anti-Recidivism Coalition. We find them housing, we get them with like-minded people, and they are still supervised by probation and by the court. And they're on GPS for the first 30 days just to get them the support and to make sure that they're not overwhelmed, because usually they come directly from the penitentiary where they had been housed. A few of them opt to be in the county jail, but a lot of them just come directly. If they were 16 years or older at the time of the offense, when they were fitnessed up to adult court, using the terminology that was used back in the day, then we, obviously have to do the transfer hearing if it's not withdrawn, and again, we try to get them services so that they can reintegrate into society. So that's sort of an overview of what we do from our perspective to try to get the transfer withdrawn at all possible before doing the hearing.
Melissa, from your experience, what effect is that having to address a transfer motion? How does that change the length of time a youth is housed pre-dispo at Los Padrinos? What are you seeing as an average time that youth are spending, fighting these cases or addressing these issues?
It increases the length of time they must stay at Los Padrinos tremendously. I would say it could take up to a year to prepare a transfer case because we're relying on experts. And there's a limited number of experts in Los Angeles County that are on the LA Superior Court panel that a judge will pay for us to assist us in our representation of the client, because we have to be effective lawyers, and we have to make sure due process is protected and that the client gets a Sixth Amendment right to counsel. So a lot of it is not dependent on us, but I would say about a year just waiting to get all the appropriate experts.
And that would be even before the hearing for the motion to transfer starts. It's kind of just an early process.
Exactly.
Okay, thank you. So once the players in the court have decided to move forward, then they start with a probation report. And actually in 1990, I was assigned to the gang unit, and that was the first report I did in Juvenile. It was a fitness report back then. And it didn't take long for me to understand how significant that report was. And because of that, I've always had an interest on it. And in 2016, when Prop 57 was passed, I actually wrote an email to the department to change their policy and their practices and their training. It finally came to existence, the new policy, and the most recent policy that I have reached out to probation to verify that the policy I have is the most current, and to see if any of the processes have started or changed. And that report came out in 2024. So it was 6 years before the department in LA County responded, and it was after numerous emails. And I share this because it is this part of the process that brings the PLC's interest into the practices, because we oversee the department, and most areas of the department, we kind of focus on juvenile because it seems where there's a lot involved in juvenile, and it's the area that we have a detention facility, and we have camps, and we have placements. So the current policy with probation is that it gets assigned out to an investigator when things are normal. Right now, because of the crisis in the hall, it just depends who's available that's going to complete the report. And once you complete a report, you basically get your supervisor to sign off. It's not done in a panel like other counties, and it's not done, the decision isn't made in a panel setting like the district attorneys, which I'm really happy that they're keeping. So what I like to share about this process, because I had to write 7 of these when I was in the gang unit, and there was a lot of pressure within the department back then in the 90s to just recommend unfit and punt and let the court sort it out. And I hope that that's not happening anymore. But when Prop 57 came out, if you go back and you look at the criteria and the number of things that the probation officer was now able to look at, because the judge was going to be able to take into account, it's significant. a significant change. I mean, it's night and day, and we're hoping that with the new training that was actually the training was about a year ago. So I'm not sure how it's going now, but understanding the significance of that report was one of the main reasons the PLC decided to have this town hall. Is just so people had an understanding of a report that is consequential. What I used to tell people is that when a youth was found unfit in the old days and moved up to the court of adult jurisdiction and then maybe assigned to or adjudicated to prison, that would be one of the reports that follow them first. And that would be the report that the prison system would use to place the kid. And if that was couched in such negative terms and not balanced, then you have a kid that, a youth that may not end up in Chino and end up in a more structured and more dangerous place. So that always weighed on me as a probation officer. And that's why paying attention to these reports and monitoring the quality of these is a key component of our oversight. Like I indicated earlier, probation was invited to sit on this panel. They did not respond. And maybe later in one of our regular meetings, they can talk about their process and their training and fill in the gaps here. I'm only able to speak with to the knowledge that I have about the system today. Once all this is completed, it proceeds to the bench. And today we are very, very fortunate to have with us Judge Catherine Lucero, who currently serves as the director of the State of California Office of Youth and Community Restoration. Judge Lucero spent many years on the bench in juvenile court in Santa Clara County, and today will share with us some of her experience with motions to transfer. Also joining her is LaRon Dennis, also with OYCR, and an expert on juvenile law, so that we can also speak about the recent changes from the state perspective. Thank you for joining us, Judge Lucero and Ms. Dennis.
Thank you. Yes, it's so good to be here. I did want to note that prior to my 22 years on the bench, I was a prosecutor for Santa Clara County. That was my first job out of law school, and really learned so much on this kind of stakeholder continuum. I did also want LaRon to introduce herself a little bit more thoroughly so that you understand the expertise that she brings not only to this panel, but to the office.
Thank you, Judge Lucero, Director Lucero. Yes, I'm LaRon Dennis, and I work as a special consultant with the Office of Youth and Community Restoration right now. I am a retired prosecutor. I was the supervisor of the Juvenile Division in Santa Clara County's DA's office for a few years. Prior to that, I've had a variety of careers. I worked for the Judicial Council as a delinquency law and policy attorney. And prior to law school, I was a probation officer in Santa Clara County for almost 13 years as well. So I understand both perspectives. I've written a fitness report myself back in the day. I testified. And when I was a DA, I know we had those kinds of hearings in front of Judge Lucero as well.
And LaRon's also a contributing author to the Cumley Sizer book that everybody reads, hopefully, on juvenile law. So she continues her legal expertise in that realm. I bring all that up because this is a very complicated area of law. It's dynamic, it's ever-changing, and there's a lot of people interested in getting it right. We've learned so much over the last 20 years about adolescent brain development. And even the US Supreme Court has cited such research in ending the juvenile death penalty and the automatic life without parole cases. Our mandate at the Office of Youth and Community Restoration, actually in the law, says that we're supposed to help youth stay in juvenile court to reduce or prevent their transfers. Because as you will note in the attachments, LaRon has done a research brief. And there is no research actually that says that youth who are committed and transferred to adult criminal jurisdiction do better or keep our community safer. In fact, the opposite is true. So we continue to look at the research, the science, and the reality of what happens to a young person who is ages at one time 14 through 17, but now 16 or 17, that is transferred to an adult court. As a judge, of course, I was required to take judicial education. So I had to keep up on this law, and it also included bias. And I just wanted everyone to know that judges do have to do continuing education, and it does have to include bias. I did a lot of transfer hearings and probably started with fitness, but turned into all transfer hearings. In 2009, there was over 1,000 youth that were committed in California to adult court. In 2016, after Prop 57, we saw a decline. In 2017, there were 158 youth transferred to adult court in the state of California. And by 2022, 23, even with COVID, considerations and rebounds, we still had very few, 20 or less. And the reason why I don't have an exact number is because DOJ statistics and our new data, there's a little bit of discrepancy, but it's very low. And I do agree with the DA's statements around how many motions and transfers there have been in LA County. We do get data from the counties on this point. That was through AB 102, and now going forward, AB 169. Very few transfer hearings are being ordered in LA. In 2021-22, it was 18 were ordered, and the judge orders that transfer hearing as soon as the motion is filed. And we heard today that is filed with a detention hearing. So that's really early. And then 22-23, we had 19, according to LA County, transfer hearings were ordered. And then in 23-24, 11. So that continued to drop. And just like the deputy DA said, only a fraction of those actually get granted. What I had to do when I was a judge making these decisions, which by the way, were the toughest decisions that I had to make. So just know that no judge takes these decisions lightly. We're required to make our findings on the record about how we make these decisions. I never made a decision without writing it down and issuing a decision, so that because I knew it would be appealed, and I wanted to make sure that the Court of Appeal understood my thinking. I had to articulate the evaluative process by detailing how I weighed the evidence. And the requirement was that when I performed this factual analysis of the relevant factors as to each criterion, which we have learned about, the degree of criminal sophistication, it wasn't enough for me just to say he was criminally sophisticated or she was criminally sophisticated. I actually had to go through the subtopics. And there are many. For example, when making this evaluation, it says that I had to include, but was not limited to, the minor's age, maturity, intellectual capacity, physical, mental, and emotional health at the time of the alleged offense, the minor's impetuosity or failure to appreciate risk or the consequences of behavior, the effect of family or other adult pressure, peer pressure, the minor's actions from the peer pressure, the effect of the environment where the youth was raised, the existence of childhood trauma, the involvement of child welfare systems, the status of the minor as a victim of trafficking, sexual abuse, or sexual battery. So I had to actually go through each of those and was happy to do it because, again, this was such a difficult decision. Whether the minor can be rehabilitated, again, there were sub-factors, including my opinion on whether or not the minor had the potential to grow and mature, which of course I'm not a child psychologist. So your expert reports were so important. The minor's previous delinquent history, and sometimes before they were excluded, that would even be informal delinquent history. That could be school issues. Really, the kitchen sink was usually brought in. The success of previous attempts by the juvenile court to rehabilitate the minor, again, A lot of our youth that find themselves in transfer hearings have long been known by systems, as they say, by law enforcement, by school officials, suspensions, expulsions. All of that would come in, including formal adjudications or at least arrests. And because again, such a big decision, everything was certainly considered. And then the gravity of the offense, I had to weigh relevant factors, including but not limited to the actual behavior, the actual role. Now, that was always a quandary, I have to tell you, because I didn't know a lot. I only knew what was in the police report. And if anybody had any mitigating factors, it could be that they came out at some point. But really, I was really looking at the four corners of the complaint or the petition, and the police reports when allowed. And then, of course, the probation report. But again, it was a very interesting process because I rarely had statements unless they were to the police after a Mirandized statement from the minor. The degree of involvement in the crime, the level of harm actually caused, and the person's mental and emotional development. So I just say all of that because I know the attorney went over all the factors, but I wanted you to know that there's some very detailed analysis that has to that I would have to go through. After the case was submitted to me, I would read everything. I would ask for judicial notice to be taken on child welfare files, on the youth's prior cases, etc. I often had expert reports that I had to read as well, body camera evidence sometimes, videos, texts, dispatcher calls, of course, the probation reports, victim statements, victim impact statements. So I'm just letting you know that it was this is a resource intense job for a judge, just as it was for all of the attorneys. But I'm the one that took it back and spent several days going through the evidence and making sure that I could apply that to the law that I was required to apply it to. In Santa Clara, similarly, the DA has a team that makes the decision about whether or not to file a transfer motion by the time of the detention hearing. That's a really short turnaround, right? That's like 48 hours unless it happened on a weekend, and maybe you've got 72 hours. Very, very grateful that that's the way that Santa Clara DA made decisions. It sounds like LA does the same. We did have our fair share of the remands from adult, and those are very different cases. And I really appreciated the description today of how those are handled in that 2-year period of control, and now what the law is. All in all, I neglected to tell you that when I make my decision, the standard now is the transfer can be ordered if I found by clear and convincing evidence based on the evaluation of the 5 factors that the youth would not be amenable to rehabilitation while under the jurisdiction of the juvenile court. So that was the judge's role. That's what happened real time. I did want to mention that now in this job, I am seeing very clearly the way that this is these decisions are being made, and the kind of the cultures in the different 58 counties. But I think very strongly the bench continues to be make themselves very available for training on everything from trauma, the impact of trauma on cognitive abilities, the adolescent brain development, and everything that we continue to learn, the issues of who comes to the attention of the authorities, and what kinds of ways we can find equity in our application of the stakeholders, and how we handle these cases. Our office does promote best practices, trauma-informed practices, gender honoring practices, and we are continuing to collect data on what's happening in the state around the transfers and kids that are being released from SYTFs and then coming back. We have the Juvenile Reentry Grant now, so we actually do have data on the number of kids being released from SYTFs. Before, the BSCC gave that number to Department of Finance, how many youth were released from DJJ, and then there would be compensation so that the county could support the youth in the community. So now SYTFs give that number to the Department of Finance, and also the number of youth who are brought back in because they need further treatment, and perhaps the first try wasn't as successful. So I don't have numbers for you today, but I'm letting you know that there are gaps in juvenile data. But I also think our office was specifically designed to understand the picture, and that we will continue to develop data points, data information, and briefs that will inform you. And if you ever want technical assistance or want more information, our office is available. Please explore our website at oycr.ca.gov. We have a lot of information. We have webinars every month on different topics. And so we're available for you to work with us. And I don't know if LaRon has anything to add.
No, I don't. Thank you.
Okay.
There's a lot there to unpack. So when I visited Sacramento, I had asked about the motion for transfer on Prop 57, and one of their executives said something to me that's kind of making more sense now after your presentation, Judge Lucero. I pointed out the criterion and how significant that was, and I argued that it's probation's responsibility to try to fill as much of that information in for the court. And they argue that it's not probation's job. That is only applied by the judge. The law basically says what the judge can take into account. It doesn't actually say probation has to, supply that information in the report. And so you also mentioned that there are areas of the criteria that you're not an expert in, which you would have to assume the same thing with probation. Given that, how significant a role did the probation report play when you were making your decisions, or did you rely mostly on the supplemental information that the public defender was providing?
I mean, it was all important. It was all important. I preferred to hear cases where everybody was really prepared and was, I preferred to have youth who were seen by experts who could tell me about their developmental phase and any other concerns, like honestly, IQ, their social IQ, emotional IQ, any disabilities. Sometimes I could find that in a child welfare file or a probation file, but I really liked as much information as I could possibly get, and I would consider all of it equally.
Thank you. Before we move on to public comment, do any of the panelists have anything to add or any questions of each other? Clarification? So I'll just ask one more. Mr. Santoro, how does that happen in 2 days?
How does what happen in 2 days? Determine whether or not we should transfer?
Yeah.
We don't do it in 2 days. So generally, and there's a couple of related legal issues. And in juvenile, when a motion to transfer is filed, the proceedings technically stop. There's no plea entered and everything is halted until the determination is made. So generally, motion to transfers are filed in murders and very serious sex cases, and then often withdrawn later when we realize that might not be the best thing to do. The last administration was horrible at making these decisions, probably for various reasons. It would take months to get a decision, and that didn't do anybody any help. So this going forward, the decisions are going to be made a lot sooner, but obviously they'll be subject to reconsideration. We're not going to wait a year to get a report from an expert like we used to do in the past, but we're not going to do it in probably 2 days either. I think we're trying, I think what we've said in our policy is to be in a reasonable time, and I think we've all agreed it's going to be a couple of weeks. And at that point, you're looking at the evidence you have, which is all the police reports, anything in the probation report, anything that maybe the defense counsel gave to the DA in the case and made its way. So it's not done so quickly, but it's done with our best ability and subject to change. We don't dig our heels in and say we're never going to change this. They change quite a lot, actually. So that's how it happens.
Thank you. Thank you.
Of course.
Bess?
Yeah, Mr. Santoro, can I ask one quick question?
Sure.
So you said that, it's a different process for these returning former minors in terms of the decision to transfer. It's not going through the committee process.
Well, no, it was under I think what I said, and I was trying to be mindful of the time limit, so I was probably speaking too quickly. The prior administration separated those into two groups, the JACE and the non-JACE, and the non-JACE were the adults. The current administration just has one policy. We're going to look at everything, write a memo for everything, and evaluate everything. Now, of course, part of the evaluation process for someone who's 50 coming back might be different than someone who's 16, but there's no formal differentiation between the group. The same people will make the decision and will look at the same factors.
Thank you for the clarification.
Of course, of course.
Okay, thank you. And now we will open the floor to our attendees to raise any questions or comments you have. Wendy, please facilitate public comment for us.
Absolutely. Wow, that was awesome. Thank you all very much. And we really encourage the folks who are attending today to ask your questions, share your comments. You can do that by clicking on the little raise your hand function. You have to be on WebEx. Unfortunately, you can't ask questions through YouTube. And as I said, if you have a question and you don't want to ask it, you can send it to us in the chat and I will read it. I will, as people are considering whether they're going to raise their hands or not, just echo what Judge Lucero said, that the OICR website is awesome. There's a lot of really great information, both data but also links to other reports from other sources of data and research. I really appreciate what you all have done on the website. I encourage people to check it out. Well, I do not see any hands. I'm surprised.
I must have asked all the questions.
That's right. That's right. You were so thorough. All right. Okay. Thank you, David. David Carroll is going to ask a question, our Director of the Department of Youth Development. Welcome, David. We're glad you're here today.
Thanks. Good afternoon. I'm David with the Department of Youth Development. I've been attending quite a few of the transfer hearings. In fact, I'll be attending one tomorrow for one of the young people that is in Los Padrinos. One of the things that I've been struck by is for young people who were transferred to the adult system for a period of time and then had challenges there, became, I guess, more entrenched in some of the negative behaviors when they were doing well, right, in juvenile, that behavior is held against them. And it's this kind of an obscure question, but it would seem that behavior would be excluded from like formal reports because they would not have been in that place had it not been for the fact that they were taken out of the juvenile system. Hopefully that question makes sense, but is there a way, I guess, to mitigate for things that I guess shouldn't have happened and their behavior in those instances?
I can try to respond to that. So if I understand your question correctly, you're talking about, say, for example, someone ends up in a really violent level 4 prison at the age of 18 and gets involved in incidents that maybe they wouldn't have if they hadn't gone to prison. Is that correct? Is that your question? David? All right. Well, I'm gonna
We
assume.
need to unmute David again so he can answer.
Oh, yep. I couldn't. I was trying. I was muted. Sorry.
Is that basically?
That's it in a nutshell. And then
Yeah.
even if they were just transferred to county jail, right, and they got involved with older individuals as a way to protect themselves, and got face tattoos or additional gang tattoos and
Yeah.
things like that, And then when they returned to juvenile, those things were held against them in their transfer hearing.
Yeah, and that is going to be come up. That is going to come up, right? Because conduct subsequent to the offense is going to come up, and so we deal with that a lot in these retroactive cases. There are experts that can come in, like say if it's prison and, for example, particular prisons during particular periods of time that were very violent, to talk about how that minor at the time could not have avoided some of those situations, or at least to give it some context, because there are experts, prison experts, and also people that were in those prisons that are formerly incarcerated that are now working with juveniles and working with the courts as experts. So we do have people that can come in and give some context to that. But both bad things that happen in prison and the positive things can be mitigating, or or they can be, the DA will argue oftentimes that that same conduct is aggravating. But what we can try to do is give it some context with some experts that actually know what that prison experience was like, or what was going on in county jail, for example, like whether or not the person really had a choice to get out of that situation, right? But it really depends on the exact allegation and the context, but we do try to bring in some mitigation there.
Okay, we have a couple of great questions in the chat. The next one is actually somewhat similar, but about the LA probation detention facilities. So as we know, Los Padrinos, where all the predisposition youth are held, has failed to meet BSEC minimum standards. Will that be a mitigating factor for youth facing transfer who may have been involved in disciplinary incidents or negative behavior that could be related to the lack of adequate staffing or the lack of programming? Would that be held against them and their amenability to juvenile court? So I think I'll ask Melissa if you'd like to answer that question, and then maybe Frank, if you have thoughts about that as well.
I think it should be mitigating, because the way it works, at least in LA County, what I've seen is that probation submits daily observation reports. And it's difficult, it can be difficult to ascertain the veracity of what information is given in the reports. For example, how do we know that it's true, or how do we know that there's very little due process, I think, from what I have seen, given to the youth who are facing these negative DORs, because there may not be any way to know whether it's true or whether the information is exaggerated, or especially when you hear of incidents like what we're seeing in the LA Times, where probation was staging gladiator fights. So the question is, did this youth actually get in a fight, or was there some sort of duress when that occurred? So I think it should be mitigating.
And just to add to that, your behavior is always going to be used against you. Past behavior prior to the incident, meaning if you had previous robbery prior to the murder that you're in custody on, that we're trying to transfer you, or how you act in juvenile hall. When you first asked your question, it sounded like you were referring to younger individuals that are pending their hearing and being held at up in Sylmar, where the people over 18 and the people pending transfer hearings are waiting and getting into fights there. That's kind of what it sounded like you were asking. And it's unfortunate. The situations are horrible. Juvenile hall I worked in juvenile hall after college, before law school, and they're not fun, pleasant places. But unfortunately, anything you do is always going to be scrutinized, and there's going to hopefully be scrutinized in an objective way. No one in the district attorney's office is going to be faulting you for not doing well in school, when we're aware of the fact that it's hard to get teachers in there, it's hard to learn, etc. We're going to be looking at more violent stuff. And I'm sure the court, and I think this question actually is probably even best answered by the court, is that they're the person who is going to decide how much weight or value to give to an incident. So if you're in juvenile hall in Sylmar, where they keep the kids pending, and it's not really juvenile hall, but it's where they house their kids pending SYTF, and you get in a fight and stab somebody, the court's going to have to, the DA is going to argue that that's clear evidence that will not be rehabilitated in juvenile, and the defense is going to argue you're sort of stuck in that situation. You had to defend yourself, and that might be true. And the court's gonna have to decide what is the value of that incident. Is that a reason not to? And you mentioned an incident where a person put on a tattoo. I think you're talking about a specific transfer case that I'm familiar with, and it was actually handled by our gang division, where the defendant is on phone calls saying, or he's telling people, I'm no longer in the gang, I'm no longer in the gang, telling probation, I'm no longer in the gang, and then he's caught in phone calls saying, I'm in the gang, and he put on new gang tattoos. So it's all going to be evaluated and weighed, and there's no right or wrong answer. And obviously each side's going to have their position, and then the court's going to have to decide. But at the end of the day, you're always responsible for your behavior, whether it's a horrible situation or not, unfortunately.
Thank you. Okay, a very straightforward question. How many youth are currently detained in LA juvenile facilities who are facing transfer to adult court? Is that a question you can answer, Frank?
That's a tough question to answer. I would have to go back and check the stats on that. And so off the top of my head, I don't know. As I mentioned, we've filed about 200 transfer cases since 2022, and a large chunk of those have been withdrawn. They've been settled. I wouldn't be surprised if we have 50, 60, 70 still pending, but that's just a ballpark guess.
Very helpful, thank you. Okay, I think this question is for Eduardo. Is the LA Probation Oversight Commission collecting data on the gender, racial, and ethnic disparities in transfer petitions? The number of youth where the petition is withdrawn, the results of the hearing, the plea agreement, as opposed to strictly the number of petitions filed and the number sent to adult court?
Not currently, and it's something that the PLC will be looking at and hoping to address with probation.
And we are collecting a lot of that, only it's under AB 102, it was annual. Under AB 169, it'll be twice a year. So stand by, check our website out if you want some information consistent with that question. It's not going to be every single detail that was just mentioned, but many of the details.
Yes.
Great, thank you. Okay, I don't see any more hands and I don't see any more questions in the chat. Janae, do you have anything else? I think that's the end of our questions.
Perfect.
Turn
So
it back to you, Commissioner Moon.
thank you. Panelists, I can't thank you enough. This was really educational, and I hope that in the days that follow, people will log in and review the recording. Follow us on our meetings on our website, and hopefully that information related to gender and the number of people in our juvenile hall will be answered soon by probation. They have their hands full right now, but that doesn't mean that this work can't continue. Our time has come to an end. Thank you all so much for joining us. Our next commission meeting is on Thursday, February 6th at St. Anne's Events and Conference Center at 9 a.m. You can find registration details on the PLC website, plc.lacounty.gov meetings. Thank you everyone for joining us, listening, and have a great, great day. Thank you.
Thanks, everybody.
Thank you for having us.
All right.